My son-in-law stood in my driveway holding a handful of new locks and said, "You don't live here anymore. This house is mine now." He'd just come from my wife's funeral. I'd buried her at 11 that morning. By 3, he was changing the deadbolts. He thought because she was gone, the property passed to him. He forgot one thing. Carol and I bought that house under joint tenancy with right of survivorship. The deed wasn't in her name alone. It was in ours together. He changed the locks. I still had the keys. My name is Frank. I'm 63 years old. I spent 31 years building bridges for the county, steel and concrete. You learn real quick that a structure only holds if the foundation is sound. This house, the one my son-in-law tried to take, Carol and I bought it when Daniel was 7. We painted every room. We replaced the roof. We planted an oak tree in the backyard the spring before she got sick, and that tree is 12 feet tall now. He thought the funeral meant the property passed to him. He didn't know about the survivorship deed. He didn't know that when one owner dies, the other gets everything automatically. No probate, no waiting, no loophole for a son-in-law with a key grinder. Let me take you back to where this really started. Not the funeral, not the lock change. 6 years before that, on a Tuesday night in late September, when Carol first told me she wasn't feeling right. She said it was just a headache, a bad one, but she'd had them before. I made her lie down on the couch. I brought her a glass of water and her blood pressure pills. She smiled at me the way she always did, like I was being sweet and silly at the same time. Then she closed her eyes. I found her 3 hours later. The stroke had happened while I was in the garage putting away the garden hose. She was 59 years old. We had been married for 34 years. The days after that are a blur of phone calls and casseroles and people saying things that were supposed to help but didn't. My son Daniel flew in from Columbus. He was 28 then, still single, still working as a sales rep for a medical supply company. He stayed for a week. He helped me sort through Carol's clothes. He packed up her jewelry box, the one her mother had given her, and asked me where I wanted it. I told him to keep it. I said Carol would have wanted him to have it. He cried. I didn't. That was the first mistake I didn't know I was making. Here's something they don't tell you about grief. It hollows you out slowly, like water wearing down stone. You don't feel it all at once. You feel it in the mornings when you reach for her side of the bed and there's nothing there. You feel it when you open the refrigerator and see the leftover meatloaf she made 3 days before she died. You feel it when you're standing in the hardware store and you realize you don't need to call and ask if she wants anything from the garden section anymore. I kept moving because that's what I knew how to do. I mowed the lawn. I fixed the gutters. I showed up to my grandson's baseball games even though he wasn't born yet. I kept the house because Carol loved that house and because I wasn't ready to let go of the last place where her presence was still warm. Daniel met Melissa about a year after Carol passed. She was sharp, funny, had a good job in pharmaceutical sales. She came to Sunday dinners. She asked questions about Carol. She seemed genuinely interested in who my wife had been. I liked her. I really did. The wedding was beautiful. Outdoor ceremony, late September, the trees just starting to turn. I paid for a significant portion of it because Daniel asked me to and because I wanted to. I thought I was investing in their future. I was, just not in the way I understood. Melissa's parents, Raymond and Gloria, showed up late to the reception. Raymond was wearing a suit jacket that didn't match his pants. Gloria had a wine glass in her hand before they even reached the seating chart. I shook Raymond's hand. He had a grip like he was trying to prove something. He told me I had a nice place, meaning the venue. He asked how much it cost per head. I changed the subject. Over the next 2 years, I watched the dynamic shift. Small things. Melissa started calling the house our house instead of Frank's house. She'd say things like, "We should really repaint the living room, don't you think, Frank?" Or when the oak tree in the backyard drops those acorns, it's a nightmare. She knew about the oak tree. Carol and I planted it the spring before she got sick. It was 12 feet tall now. Melissa noticed everything. I told Daniel about the comments. He laughed it off. "She's just trying to be involved, Dad. She wants to feel like family." I let it go because I wanted to believe him. I wanted to believe that the woman my son married, the mother of my future grandchildren, was not watching my house like a piece of property she was already measuring for curtains. Then came the Tuesday after Thanksgiving. Melissa showed up at my door with a binder, not a folder, a binder. She sat down at my kitchen table, opened it to a tab marked Proposal, and explained that Raymond and Gloria were being evicted from their rental in Lancaster. The landlord was selling. They had 60 days to vacate. She said they'd looked everywhere and found nothing affordable. Then she said the words that played on a loop in my head for the next 3 weeks. "You have 4 bedrooms, Frank. You live alone. It just makes sense." I said no. I said it calmly. I said it clearly. I said it in front of Daniel, who sat in the corner of the kitchen staring at his hands like they held the secrets of the universe. I said, "This is my home. I will not have 2 strangers living in it." Melissa's face went still. She closed the binder. She stood up. She said, "I'm going to pretend you didn't say that. We'll talk when you've had time to think about it." And she walked out. That was the moment I should have understood what I was dealing with. The problem was, I still saw her as family. I still saw a woman who had married my son, who had held my hand at Carol's grave, who had promised to love and protect Daniel for the rest of her life. I didn't see her as an adversary. I didn't see her as someone who would weaponize my own kindness against me. She called me every day for the next week, then twice a day. Then her parents started calling. Raymond left voicemails about family obligations and what Carol would have wanted. Gloria sent a handwritten note that began, "Dear Frank, I know you're a reasonable man," and ended with a postscript asking if I'd considered how this made her look at church. I kept saying no. I kept documenting everything. I wrote down dates, times, what was said. I filled a spiral notebook in 3 weeks. On December 15th, I came home from dinner with my friend Howard to find Raymond's silver Chevy Silverado parked on the street in front of my house. He and Gloria were sitting inside. When I pulled into the driveway, they got out. Gloria was holding a casserole dish. Raymond was smiling the smile of a man who has decided the answer to a problem is simply to show up. "We thought we'd come say hello," Gloria said. "I made my chicken and rice." I took the dish. I thanked them. I did not invite them inside. I went in and locked the door. Through the front window, I watched them sit in that truck for 20 minutes before driving away. 2 nights later, they were back. This time, they knocked at 9:30 at night. I answered in my bathrobe. Raymond said they were in the neighborhood. I told them I was heading to bed. I closed the door. I called Daniel the next morning. I told him that if his in-laws showed up at my home uninvited again, I would call the non-emergency police line and report it as harassment. He apologized. He sounded exhausted. He said Melissa was really stressed and that her parents didn't have anywhere else to go. I told him I loved him. I told him my door was always open to him. I did not tell him the other thing I was thinking, the thing I was beginning to suspect, that Melissa had never intended to ask. She had intended to present me with a situation so impossible to refuse that I would have no choice but to say yes. And when that failed, she had a plan B. I just didn't know what it was yet. On a cold Tuesday morning in January, I received a letter from a law office. The name on the letterhead was Gerald Hutchins, attorney at law. It stated that his clients, Raymond and Gloria, were asserting a claim of implied tenancy based on an alleged verbal agreement to allow them to reside in my property. The letter demanded that I honor this agreement or face legal action. I read it twice, then I laughed, not because it was funny, because I am a civil engineer. I know what a contract looks like. I know what an agreement looks like. I had made no such thing, but someone had lied on paper under an attorney's signature to try and take my home. I called Susan Park that afternoon. She was the attorney who handled Carol's estate. She was sharp, no nonsense, and she did not waste my time. I told her everything. She asked 2 questions. "Did you ever tell them they could move in?" I said no. "Did you put anything in writing that could be interpreted as permission?" I said no. She was quiet for a moment. Then she said, "Frank, do you have documentation of every interaction?" I told her about the spiral notebook. I told her about the voicemails I had saved. I told her about the texts. She said, "Good, send me everything." That was on a Wednesday. On Friday, I came home to find a locksmith's van in my driveway, and a man I did not recognize standing on my front porch, holding a cordless drill and a bag of new deadbolts. Behind him stood my son-in-law, who said 4 words that I still cannot say without my jaw tightening. "Get your stuff out." I stood there in my own driveway, staring at the locksmith's van with its magnetic sign on the side. Greenfield lock and key. The van was parked right where Carol's old minivan used to sit. The man with the drill was maybe 30, wearing a blue work shirt with a name patch that said Randy. He looked uncomfortable, like he'd realized this wasn't a routine service call but didn't know how to back out. Behind him, my son-in-law crossed his arms. His name is Brian. He'd been married to my daughter Emily for 4 years. Emily was Carol's and my only daughter, born 2 years after Daniel. She lived in Cincinnati with Brian and their 2 kids, ages 6 and 4. I'd always thought Brian was fine, quiet, kept to himself, worked in logistics for a shipping company, never caused trouble. Until that Friday afternoon. "Get your stuff out," he said again. "The house is being secured." I looked past him at my front door. The old brass deadbolt, the one Carol picked out when we replaced the doors in 2002, was already lying on the porch. Randy had removed it. The new deadbolt was still in its plastic clamshell, sitting on the step. "You changed my locks," I said. "Not a question, a statement." "Emily and I own the house now," Brian said. "She inherited it when Carol died. I'm the executor of the estate. We're taking possession." I felt something cold settle in my chest. Not fear, something else, clarity. "Brian," I said, keeping my voice level, "who told you that?" Melissa's attorney looked into it. The property passed to Emily as next of kin. That's how inheritance works. Melissa, my daughter-in-law, the woman who had wanted her parents to move into my house, the woman who had sent Raymond and Gloria to my doorstep with casseroles and threats. She had put Brian up to this. She had convinced my own son-in-law that he had a claim to my home. I looked at Randy, the locksmith. "Did you verify who owns this property?" Randy shifted his weight. "I was told the owners were Brian and Emily Carson. They showed me a death certificate and a quitclaim deed." "A quitclaim deed," I repeated. "From who?" "From the estate," Brian said. "Emily signed it over to me and her jointly. We are filing it Monday." I didn't laugh this time. I didn't get angry. I pulled out my phone and dialed Susan Park's number. She answered on the second ring. "Susan, I need you to tell me something. Is it possible for someone to file a quitclaim deed transferring property out of my name without my signature?" She was quiet for exactly 2 seconds. Then she said, "Frank, who's trying to file a quitclaim deed on your house?" "Apparently my daughter Emily, through my son-in-law Brian, who is standing in my driveway with a locksmith who already removed my deadbolt." "Don't let him change that lock. Do you have your keys on you?" "I have my house keys in my pocket." "Go to your door, insert your key into the existing lock. If it still works, you have legal access. If it doesn't, call the police immediately and report a break-in." I walked past Brian and Randy. I knelt down, picked up my old deadbolt from the porch and placed it on the step. Then I inserted my key into the remaining lock on the front door. The bottom lock, the one Randy hadn't gotten to yet. It turned smoothly. The door opened. I stepped inside. I closed the door behind me. Through the glass panel, I saw Brian's face go red. Randy was already packing up his drill. I called the Greenfield Police Department non-emergency line. I told the dispatcher that someone was attempting to illegally change the locks on my residence and that I was inside the property with proof of ownership. She said an officer would be dispatched. I sat down at the kitchen table. I opened my laptop. I pulled up the county property records website. I typed in my address. The screen loaded and there it was. Frank and Carol Henderson, joint tenants with right of survivorship. Date recorded, October 12, 1998. The key legal fact that Brian and Melissa and their attorney had either overlooked or ignored. A joint tenancy with right of survivorship means that when one owner dies, the surviving owner receives the entire property automatically. There is no probate, no estate distribution, no passing to adult children. The property is not part of the deceased's estate at all. Carol's name was removed from the deed automatically the moment the death certificate was filed. My name remained, sole owner. A quitclaim deed signed by Emily would be worthless. She had no interest to convey. She never owned a piece of this house. The police arrived in 10 minutes. Officer Martinez, a young woman with a calm voice and a steady gaze, I explained the situation. She spoke to Brian outside. I watched through the window. Brian was gesturing, pointing at the removed deadbolt at the locksmith van at me. Officer Martinez listened. Then she walked up to my door and knocked. I opened it. Mr. Henderson, your son-in-law claims he has a legal right to change the locks. Do you have proof of ownership? I handed her my phone with the county property records page open. She looked at it. She looked at Brian. She handed it back. Mr. Carson, she said, this property is solely owned by Frank Henderson. You do not have the legal right to change the locks or exclude him from the residence. You need to vacate the premises immediately. The locksmith needs to leave as well. Brian's face drained of color, but the death certificate does not transfer ownership when there is a survivorship clause. That's Ohio law. If you have a dispute, you need to take it to civil court. You cannot take it to a locksmith. Randy was already in his van. He pulled away without looking back. Brian stood alone in the driveway. He didn't look at me. He walked to his car and sat there for a long moment, his hands on the steering wheel. I went inside. I made coffee. I sat down at the kitchen table and wrote down everything. The date, the time, the name of the locksmith, the name of the officer, the exact words Brian had said. I photographed the removed deadbolt. I saved the county property records page as a PDF. Then I called Susan Park again. He tried to change my locks using a quitclaim deed from Emily, I said. Emily can't sign a quitclaim deed on property she doesn't own, Susan said. That deed would be void ab initio. Void from the beginning. It's not worth the paper it's printed on. Susan, someone told Brian he owned this house. Someone gave him a legal strategy. This didn't come from a logistics manager in Cincinnati. I know, she said. I've been doing some research. Gerald Hutchins, the attorney who sent the implied tenancy letter, he's the same attorney who incorporated a real estate holding company for Melissa's parents 2 years ago. Raymond and Gloria set up an LLC called R&G Property Ventures. They were planning to acquire properties. Acquire them how? I don't know yet, but Frank, this is not just about your house. This is a coordinated effort. Someone is trying to take your home through a combination of harassment, false legal claims, and now a fraudulent quitclaim deed. You need to prepare for a bigger fight. I stared at the oak tree in the backyard, 12 feet tall. Carol's tree. I remembered planting it together, her hands covered in soil, laughing at something I'd said. What do I do? First, file a police report for attempted illegal lockout. I'll draft a cease and desist letter to Brian, Emily, Melissa, Daniel, Raymond, Gloria, and Gerald Hutchins. Then we go on a fence. We file a quiet title action to confirm your sole ownership. And we consider filing a complaint with the State Bar Association against Hutchins. How long does that take? Quiet title action can take 60 to 90 days. The cease and desist goes out Monday. But Frank, here's the thing. They've shown their hand. They used the lock change as a pressure play. When it failed, they'll try something else. You need to be ready. I was ready. I had been ready since the day Carol died. I just didn't know the fight would come from inside my own family. That night, I drove to the county courthouse and requested a certified copy of the recorded deed. The clerk printed it. Frank and Carol Henderson, joint tenants with right of survivorship, recorded 1998. I paid $5 and walked out with the proof in my hands. At home, I put the deed in a fireproof safe. Then I called Daniel. He answered on the second ring. Dad, everything okay? No, Daniel, it is not okay. Did you know that Brian tried to change the locks on my house today? Silence, long silence. Dad, I didn't know, I swear. Melissa told me Brian was handling some paperwork for Carol's estate. I didn't know he was going to do that. Melissa knew. Melissa told him he owned the house. She's been planning this since before Carol died. Dad, that's not. Daniel, I have a spiral notebook full of dates and times. I have voicemails, I have texts. I have a locksmith's name and badge number. I have a police report. Do not tell me what is and is not true. He was quiet. I heard him breathing. Melissa's been telling me you were being unreasonable, he said finally, that you were hoarding the house, that you didn't want to help Raymond and Gloria. She said you were making things up. She told you I was making things up. She said you were paranoid, that you didn't trust anyone. She said Carol's death messed with your head. I closed my eyes. I was 63 years old. I had built bridges that thousands of people drove across every day. I had raised 2 children. I had buried my wife, and my son's wife had convinced him I was losing my mind. Daniel, I want you to come over tomorrow morning. Just you, bring nothing. Tell Melissa you're going to get groceries. I need to show you something. What do you need to show me? A copy of the deed, the police report, the voicemails Raymond left me, and a question I need you to answer honestly. What question? Did you know your wife was trying to take my house before Carol was even in the ground? The line went dead. He hung up. I sat in the dark living room. The oak tree cast a shadow across the lawn. I thought about Carol. I thought about what she would say if she could see this. She would be furious at me for not seeing it earlier, at them for doing it, at the whole situation. Then I thought about something she used to say. The only way to win against people who think they're smarter than you is to let them keep thinking that, right up until the moment the trap snaps shut. I went to bed. I slept better than I had in months. The next morning at 7:00 a.m., Susan Park called. Frank, I need you to come to my office. There's something you need to see. What is it? Raymond and Gloria filed a police report this morning claiming you threatened them with physical violence. They have a witness. A witness who? Melissa. I drove to Susan's office with the certified deed in my jacket pocket and the spiral notebook in my hand. Her office was on the 2nd floor of a brick building on Main Street, above a bakery that made the best cinnamon rolls in Greenfield. I'd been there twice before, once when Carol died, once for the fence dispute. Each time, Susan had been the calmest person in the room. Today, she looked like she hadn't slept. She laid 3 documents on her desk: the police report Raymond and Gloria had filed, a witness statement signed by Melissa, and a temporary protective order request that Gerald Hutchins had already submitted to the county courthouse. He filed for a protective order, I said. That's the next step, Susan said. The police report is step 1. The protective order is step 2. If a judge signs this, you could be ordered to stay away from Raymond and Gloria. That means you can't go within 500 feet of them, including their church, their grocery store, and since they listed your neighborhood as a location where they have reason to be, potentially your own property. My property, they don't live there. They listed your address as a place they frequent. They claim they have personal belongings stored in your garage. Is that true? I thought about it. Carol had a box of Gloria's things from a church rummage sale 3 years ago. Gloria asked to store it temporarily. I put it in the garage, never asked for it back. That's enough for them to claim a property interest, Susan said. Not a legal one, but enough to muddy the waters in a protective order hearing. Frank, I need you to tell me exactly what happened when you supposedly threatened them. I told her I laid out every interaction, the casserole visit, the nighttime knock, the voicemails, the text messages, the driveway incident with Brian and the locksmith. I showed her the notebook. She read through it silently, flipping pages, occasionally nodding. Here's the problem, she said. Melissa is claiming that on the night of December 17th, you called Raymond and left a voicemail saying, and I quote, "If you step foot on my property again, I will make sure you regret it." That's not what I said. It doesn't matter what you said. It matters what she says you said. And since she's the only witness to that voicemail, it's her word against yours. I have the voicemail saved on my phone. Susan looked up. You have the voicemail you left Raymond. No, I have the voicemail Raymond left me. 3 of them, including the one where he says, "I'll regret it." Play them. I pulled out my phone. I found the voicemails in the saved folder. The first one was rambling, civil but desperate. The second one mentioned witnesses to a promise that didn't exist. The third one was the one I'd played for Susan before, Raymond's voice, loud and unsteady. You have destroyed my family. You will understand consequences. You think you're safe in that house? You're not safe anywhere. I know people. I know how to make things happen. Susan listened to all three. When the third one ended, she leaned back in her chair. Frank, you need to file a counter-complaint. Harassment, Tuesday night visits, threatening voicemails, the attempted lockout. I want to submit all of it to the judge before the protective order hearing. When is the hearing? Tomorrow morning, 9 a.m., Judge Weston's courtroom. Judge Patricia Weston, the same judge who had presided over the implied tenancy case that had gone nowhere. I remembered her methodical, unhurried demeanor. I remembered how she had listened to Raymond's voicemail in open court without changing expression. I remembered how she had ruled in my favor completely. That's good, I said. Why is that good? Because Judge Weston has already seen their pattern. She read the implied tenancy filing. She heard the voicemail. She knows what kind of people they are. Susan nodded slowly. That's true, but Frank, this is a different proceeding. Protective orders are handled differently. The standard of proof is lower. If the judge finds that Raymond and Gloria have a reasonable fear of you, she can issue the order even if the evidence is thin. What's our best play? We file a cross-complaint for harassment. We submit your documentation. We show that they have a pattern of escalating behavior, that the lock change attempt was part of that pattern, and that this police report is retaliation. And we ask the judge to deny their request and consider sanctions against Hutchins for filing a frivolous protective order. Will she do that? I've seen her do it before, but it's not guaranteed. Frank, I need to ask you something. Do you have any independent witnesses to any of these interactions? I thought about it. The neighbor across the street, Mrs. Delgado, she saw Raymond and Gloria sitting in the truck that night. She said something to me about it the next day. She said, Frank, you have visitors who sit in cars. Would she testify? I can ask. Do it today. I need her name and number by 5 p.m. I left Susan's office and walked across the street to Mrs. Delgado's house. She was 82 years old, a widow like me, with 3 cats and a garden she tended every morning. She opened the door before I knocked. Frank, I've been waiting for you. Have you? Cindy across the street told me about the locksmith. Then I saw the police car. Then I saw that boy Brian sitting in his car for 20 minutes looking like he'd been spanked. What is going on? I told her briefly. She listened without interrupting. When I finished, she said, them 2 in the truck. I remember, I told you about it. You want me to say that in court? Yes, Mrs. Delgado, I do. Good, I've been wanting to say something about those people since the first time they showed up. I don't like the way they look at houses. That evening I went home and prepared a folder. I printed out the county property records. I printed the text messages. I transcribed the voicemails. I included a photograph of the removed deadbolt. I wrote a timeline of every interaction from the initial binder meeting to the locksmith incident. I added Mrs. Delgado's written statement, which she had signed in my kitchen over a cup of tea. At 8:00 a.m. the next morning, Daniel called. Dad, I need to tell you something. I'm listening. Melissa told me about the protective order. She said you threatened Raymond. Did she show you the police report? No. Did she play you the voicemail she claims I left? No. Daniel, I have a voicemail from Raymond in which he threatens me. I have 3 weeks of documented harassment. I have a police report for an attempted illegal lockout. And I have a certified deed showing that house belongs to me. Your wife is lying. He was silent for a long time. Then he said something I didn't expect. Dad, there's something else. Melissa's parents have been planning this for a year. I found an email. She left her laptop open last night. It was from her mother, Gloria. It had an attachment, a document called Property Acquisition Strategy. I didn't open it, but the subject line was Phase 2. My blood went cold. Daniel, I need you to forward me that email. Don't tell Melissa, don't say anything. Just forward it to me and Susan Park. I can't. She took the laptop to work. When will it be home? She's working late tonight. I can get it after she goes to sleep. Do it, and Daniel, I need you to understand something. If you help me, you are choosing a side. You are choosing your father over your wife. Are you ready to do that? I don't know, Dad, but I know she's lying, and I can't pretend I don't know that anymore. I arrived at the courthouse at 8:45. Susan was already there, standing outside Judge Weston's courtroom with a stack of documents. She looked more confident than she had yesterday. I filed the cross-complaint this morning, she said, and I spoke to Judge Weston's clerk. She read the summary. She asked to see the voicemail transcripts. That's good. That's very good. Weston is a reader. She reads everything. If she's already looking at the transcripts, she's already questioning their story. At 9:00, the courtroom opened. Raymond and Gloria were seated at the plaintiff's table. Gerald Hutchins sat next to them, wearing a suit that looked like it cost more than Raymond's truck. Melissa was in the front row behind them. Daniel was not with her. Judge Weston entered. We rose. She sat down, adjusted her glasses, and looked at the file in front of her. Mr. Hutchins, I have reviewed your request for a temporary protective order. I have also reviewed the respondent's cross-complaint and supporting documentation. I have a few questions before I proceed. Of course, Your Honor. Your clients claim that Mr. Henderson threatened them via voicemail on December 17th. Do you have a recording of this voicemail? Hutchins shifted. Your Honor, my clients did not record the voicemail. They reported it contemporaneously in their written statement. Mr. Hutchins, in a he-said-she-said situation, I generally give more weight to documented evidence. Mr. Henderson has submitted 3 voicemails from your client Raymond, including one that contains explicit threats. He has a recorded timeline of unannounced visits, including 2 late-night appearances at his residence. He has a police report confirming an attempted illegal lockout. Your clients have a written statement and a witness who is their daughter. Your Honor, the witness is independent. Mr. Hutchins, the witness is your client's daughter and the respondent's daughter-in-law. That is not independent. That is familial. I am denying the protective order request. I am also advising your clients that further harassment of Mr. Henderson may result in sanctions. The respondent's cross-complaint for harassment is noted and will remain on file. Raymond stood up. This is ridiculous. He threatened me. Judge Weston looked at him. Mr. Raymond, I am going to ask you to sit down and remain silent unless addressed by counsel. If you cannot do that, I will hold you in contempt. Raymond sat down. Gloria was crying. Melissa's face was stone. The gavel came down. Court adjourned. Outside, Susan shook my hand. That went better than I expected. She didn't even hear the evidence. She read it, that was the evidence. She saw the pattern. She knows they're the aggressors. Frank, I think this is the beginning of the end, but we're not done yet. They still have the quitclaim deed filing on hold, and I found something else. What? R&G Property Ventures, the LLC that Raymond and Gloria set up. It's not just a holding company, it has an address listed, a P.O. box in Lancaster, but the registered agent is Gerald Hutchins, and the initial filing date is 8 months ago, 8 months before Carol died. I stopped walking. 8 months before Carol died. They started planning this before she had the stroke. Frank, I can't prove that, but the timing is suspicious. I'm going to file a motion to depose Hutchins. I want to know who else is involved in that LLC, and I want to know if they've done this before. I looked across the street at the courthouse steps. Raymond and Gloria were walking down, Melissa between them. They didn't look at me. They got into a car and drove away. I thought about Carol. I thought about the oak tree. I thought about the 12 feet it had grown since we planted it together. And I thought about what I would do if I found out that these people had been planning to take my home before my wife even took her last breath. I spent the next 3 weeks doing what I know best. I built a case, piece by piece, document by document. I worked with Susan Park to trace every thread of the R&G Property Ventures LLC. We subpoenaed bank records. We filed discovery requests. We deposed Gerald Hutchins. Hutchins arrived at the deposition looking like a man who had realized his clients had lied to him. He sat at the table with his own attorney, a woman named Diane Reyes, who specialized in legal ethics. Within the first hour, the truth began to surface. Hutchins admitted that he had not independently verified the implied tenancy claim. He had relied on Raymond and Gloria's representation that I had made a verbal agreement. He had not asked for documentation. He had not recorded any conversation. He had simply filed the letter. He also admitted that he had prepared the quitclaim deed transferring my property to Brian and Emily without verifying the chain of title. He had assumed, as he put it, that the property would pass to the children and that the death of one spouse meant the property went into the estate. When Susan asked him if he understood the difference between joint tenancy with right of survivorship and tenancy in common, he paused for 7 seconds before saying, "I am not a real estate specialist." Diane Reyes wrote something on a notepad. She did not look happy. The deposition lasted 4 hours. By the end, we had Hutchins on record admitting he had failed to perform basic due diligence. He had not reviewed the deed. He had not verified ownership. He had not understood the survivorship clause. He had prepared a legal document transferring property that his clients did not own and could not convey. Susan filed a motion for sanctions and a complaint with the Ohio State Bar Association the following day. Raymond and Gloria were served with a subpoena for their personal financial records. The bank statements showed something interesting. In the 6 months before Carol died, Gloria had made 3 deposits totaling $12,000 into an account she shared with Raymond. The deposits came from an account belonging to Melissa and Daniel. Susan called Daniel. "Daniel, I need to ask you something. Did you and Melissa give her parents $12,000 between March and August of last year?" He was quiet. "She told me it was for her parents' medical bills. Raymond had a back surgery consultation." "Did you see any medical bills?" "No, she handled the finances." "Did you know that money was deposited into an account that was later used to fund R&G Property Ventures?" Silence. "Then, I need to go." He hung up. The next evening, Daniel showed up at my door. He looked like he had been crying. He sat at the kitchen table, the same table where he had done his homework as a child, where Carol had served him pancakes on Saturday mornings. "Dad, I found the email, the one from Gloria about Phase 2. I opened it." He slid his phone across the table. I read the email. Gloria had written to Melissa, "Phase 2 is ready. Brian has agreed to help with the quitclaim. Raymond spoke to Frank last night and he is stubborn. We need to escalate. The LLC is set up. Once we get possession, we can bring in investors. The equity in that house is worth $300,000 minimum. Your father-in-law is sitting on a gold mine and doesn't even know it." I read it twice, then I read it again. Daniel said, "Dad, she's been planning this since before Mom died. She didn't marry me because she loved me. She married me because you had a paid-off house and she knew someday you'd be alone." I didn't say anything. I couldn't. "I'm leaving her," he said. "I already told her." She went to her parents' house. I took the kids to my sister's. Emily knows everything. She's devastated. She didn't know Brian was involved. Emily didn't know. She thought Brian was helping with the estate paperwork. She didn't know about the quitclaim deed until I told her. She signed it because Brian told her it was routine. She trusted him. I thought about Emily, my daughter. She had married Brian 4 years ago. She had 2 children, ages 6 and 4. She lived in Cincinnati. She came home for Thanksgiving and Christmas. She called me every Sunday. Does she want to press charges? I don't know, Dad. She's still processing. She might. She feels betrayed. I looked at my son. He was 34 years old, and he looked like a boy who had just discovered the world was not the safe place he had believed it to be. "Daniel, I'm not going to tell you what to do about your marriage. That's your decision. But I need to tell you something. You are my son. You will always be my son. And I am proud of you for bringing me that email." He cried. I held him. It was the first time I had held my son since Carol's funeral. The quiet title action proceeded faster than expected. Susan filed the complaint, and because my ownership was uncontested by any legitimate party, the court entered judgment in my favor within 45 days. A certified copy of the judgment was recorded with the county. The house was mine, solely mine, forever. Gerald Hutchins received a letter from the State Bar Association. He had 30 days to respond to the complaint. 3 weeks later, I received a notice that he had voluntarily surrendered his license to practice law. He would not be representing anyone again. Raymond and Gloria were served with a restraining order, this time from Daniel. He had filed it after Gloria sent him a text message that said, "You have destroyed this family. Your father is a monster. We will not stop." Judge Weston granted the order. It prohibited Raymond and Gloria from contacting Daniel, Emily, or me. It also prohibited them from coming within 500 feet of my property. I installed a security camera system, not because I was afraid, but because I was done leaving things to chance. Melissa filed for divorce. There was no contest. Daniel was awarded full custody of the children. She was granted supervised visitation. The divorce was finalized in August, 11 months after Carol died. Daniel moved into a rental house 3 blocks away from my home. He brought my grandchildren to see me every Saturday. The children, my grandchildren, Matthew 6 and Lily 4, they didn't understand what had happened. They only knew that Daddy lived in a new house now, and sometimes they got to see Grammy and Poppy. Poppy was me. Grammy had been Carol. One Saturday in September, Matthew asked me, "Poppy, why did Brian go away?" I looked at Daniel. He nodded. "Brian made some bad choices, Matthew. He hurt your mom and your aunt. Sometimes people make choices that hurt the people they love, and then they have to live somewhere else." "Did you make bad choices too?" "No, Matthew, I didn't, but I almost made one. I almost let people take something that was mine just because they asked loudly enough. But I didn't. I said no." "Good," Matthew said. "I like your house. It has the best tree." He was talking about the oak tree, 12 feet tall, Carol's tree. I sat on the front porch that evening, watching the sunset through the leaves. Daniel came out and sat beside me. "You know, Dad, when Mom died, I thought I understood what loss was. But I didn't. I didn't understand until I realized that the person I married was not the person I thought she was." "None of us knew," I said. "That's the thing about people like Melissa and Raymond and Gloria. They show you what they want you to see, they wait, they plan. And then, when you're most vulnerable, they step forward and take what they believe they deserve." "Did you ever suspect?" "Not at first, but I had a moment. The binder. When she came to my house with the binder and the proposal and the timeline. That was the moment I knew she had been thinking about this longer than she had let on." "Why didn't you say something?" "I did. I said no, and I wrote it down. That's all I could do. That's all any of us can do. Say no clearly, document everything, and trust that the truth, if you keep it close, will eventually surface." Daniel nodded. He stood up. "I'm going to take the kids home. They have school tomorrow." "Good night, son." "Good night, Dad." I watched him walk down the driveway. The oak tree cast a long shadow across the lawn. I thought about Carol. I thought about the day we planted it, her hands in the soil, laughing. And I thought about the envelope that had arrived that morning, a plain white envelope with no return address. Inside was a single sheet of paper. It was a notice from the Ohio Department of Taxation. I had been selected for a random audit of my property tax exemption status. The audit request was dated 10 days after Carol died. I looked at the letter again, then I looked at the date, then I looked at the postmark. It had been mailed from Lancaster, Ohio, Melissa's hometown. I set the letter down. I didn't panic. I didn't call Susan. I didn't call Daniel. I simply filed the letter in the safe, next to the deed, next to the quiet title judgment, next to the spiral notebook. Because I had learned something over the past year. When people like Melissa and Raymond and Gloria fail, they don't stop. They just try something else. But I was ready. I had the deed. I had the documentation. I had the judgment. And I had a 12-foot oak tree in the backyard that reminded me every single day that the things worth keeping require you to stand guard. The fight for my home was over, but the fight for my peace had only begun. The fight for my home was over, but the fight for my peace had only begun. The tax audit letter I found in my mailbox, the one postmarked from Lancaster, Melissa's hometown, turned out to be the last card they had to play. I handed it to Susan Park. She made one phone call to the Ohio Department of Taxation. It turned out the audit request had been filed anonymously through an online portal, using an email address traced back to a public library computer in Lancaster. The audit was dismissed within a week. No basis, no merit. Just one more attempt by people who could not accept that they had lost. I did not press charges, not because I was merciful, but because I was tired. I had spent a year of my life defending something that should never have been attacked in the first place. I wanted to move forward, not backward. Daniel moved into his rental house with the kids. He started therapy. He joined a support group for divorced fathers. He called me every Sunday, and every Sunday I answered. We talked about the kids, about work, about the oak tree. We did not talk about Melissa or Raymond or Gloria. They had taken enough of our conversation. Emily divorced Brian. She moved back to Greenfield with her 2 children. She bought a small house on the other side of town. She started coming to Sunday dinners again. One evening, while we were washing dishes, she said, "Dad, I'm sorry I signed that deed. I should have known better." I told her what I had told Daniel. You cannot blame yourself for trusting someone who is lying to you from the beginning. The fault belongs to the liar, not the one who believed. She cried. I held her. We stood in the kitchen, the same kitchen where Carol had taught her to make pie crust, the same kitchen where she had learned to stand on a stool and reach the counter. The oak tree turned gold in October, then it dropped its leaves, then it stood bare through the winter, waiting. I sat on the front porch on a cold January morning, drinking coffee. The neighborhood was quiet. The sun was rising over the rooftops. I thought about all the things I had learned in the past year. I learned that family is not always blood. Sometimes family is the neighbor who waves at you every morning, the friend who brings you soup when you are sick, the attorney who works weekends because she believes in your case. I learned that saying no is not an act of cruelty. It is an act of clarity, and clarity is the foundation of everything that lasts. I learned that a house is not just walls and a roof. It is the sum total of every choice you made to keep it standing, the paint you chose, the roof you replaced, the tree you planted, the memories you refused to surrender. And I learned that the people who try to take what is yours will always tell themselves they deserve it. They will build entire worlds of justification. They will recruit allies. They will file paperwork. They will change locks. But if you hold the deed, if you hold the documentation, if you hold the truth in your hands, you do not need to shout. You only need to show up. The oak tree will bloom again in spring. My grandchildren will climb it. Daniel will bring them over on Saturday mornings. Emily will bring pie. And I will sit on this porch, with my coffee, with my deed, with my keys. If you want to know who really owns a place, do not look at who is making the most noise. Look at who is still standing when the noise stops. This is Frank Henderson. Thank you for listening to my story. If you want to see more true stories about property, family, and the fights that define us, hit subscribe and turn on notifications. There is always another story waiting.